We have a major update on a story out of Oklahoma that has shocked the nation. We're talking about now 18-year-old Jesse Butler, who, as we know, pled no contest to nearly a dozen charges like rape and attempted rape, and thanks to a sudden assignment of youthful offender status, he got probation, not prison time. But now, one of the teen girls that he subjected to horrific abuse is filing a lawsuit, and it's not just her ex she's going after. For those of you who are wondering whether or not he got preferential treatment and why, the new allegations in this new lawsuit may tell a new piece of the story. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, as we're covering this as quickly as possible, trying to get you these clips as quickly as possible, if you're in the content creation game, if you're putting things out on social media, if you're wondering how we're able to do that, how we're able to share so many of these clips from these rapidly developing stories so quickly, we use something called Opus Clip. This is an all-in-one AI editor that makes it so easy to cut, create, and upload videos across any platform. Through AI, Opus Clip generates B-roll, it reframes footage, and it even cleans up audio. It is so easy. You just visit opus.pro/sidebar. You sign up, you upload, and in minutes you have perfectly edited clips ready to go. For TikTok, Shorts, Reels, Opus Clip is your one-stop shop. Having a tool like Opus Clip means that our producers can get you viral courtroom updates instantly. This is the most powerful tool there is to help you share ideas and edit like a pro. So go to opus.pro/sidebar to create your videos today.
So we're here, we're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman.
Yep, you might have remembered that. Stillwater, Oklahoma high school student Jesse Butler tearing up as he was arrested at his parents' home back in March. Two of his ex-girlfriends were accusing him of serious abuse during their relationships, everything from rape to strangulation. It was a shocking case, to say the least. And I'll tell you what, according to an affidavit that was filed in this court case, Butler actually recorded himself on his phone choking one of the girls until she passed out. And his brutal behavior reportedly led to one of the victims being admitted to a hospital, that she would end up having surgery to repair damage to her neck. That's according to her mother. Now, here's the thing. This is what we want to talk about. One of the victim's family members has now filed a federal lawsuit claiming school officials not only refused to protect this victim, but that they tried to intimidate her into dropping the claims against Butler. Now, we're going to do a deep dive into this lawsuit. We're going to get really into these new harrowing allegations. But also, if all of this is true, this tells a whole other piece of this story, okay? So first, to make sense of it, to put it all into context, you need to know the bigger picture. And honestly, there is really no better place to start than taking a look at Butler's reaction and his mom's as Stillwater police slapped on the cuffs.
Okay. Okay. All right, let me know. Thank you. Hello?
Hello. Are you Jackie?
Yes, I am.
Hi, Jackie. I'm Detective Bruce with the Stillwater Police Department. We're here because we have a warrant for Jesse's arrest. I assume you know that already. Okay. Is he here?
Yes.
Okay.
I told him not to answer the door till I got home. He's scared to death,
So here's what's going to happen. Like, we're going to take him into custody. His bond is $25,000.
Okay.
Once he gets to the jail and we get him booked in, well, I guess on the way to the jail, I guess you could contact a bondsman.
Yeah.
Or I mean, if you have 25 grand lying around, you can do that. But if you contact a bondsman, then they can post his bond and he can get right out today.
Okay.
So, and
like, what kind of time frame does that look like? Just out of curiosity, like midnight tonight or
no,
an hour?
Like, you can contact a bondsman and it'll be like an hour and a half or something.
Candy Baker, I'm sure y'all know Candy.
So
she's the one that told me.
It's a pretty quick process. Okay. We just have to get him booked in. Okay. And then once he's booked in, and just so you know, he is a juvenile, so he won't be with any adults. He can't be housed with any adults. Okay. So there is a chance that he may be moved over to Payne County, but for right now, depending on how long it takes you to get with her and get bond set up,
her right back. So
then he'll probably just be at our facility at the city of Stillwater.
Okay.
And she can
Whose
come over
call
there.
is that?
It just we can only hold him for 6 hours.
Oh, okay. So if I get it done now, we're good.
Yeah.
He's not going to be moved.
No.
Okay, perfect. Okay.
Yeah, he shouldn't be. The only big holdup is if we have somebody else in the jail because we can't have them intermingle. Like if they're booking somebody in, it could hold us up like maybe 15, 20 minutes, something like that. But it's not going to be a long thing generally.
Well, we're ready to tell our story too.
Yeah.
Jess, it's Mom. Open the door. Give me your wallet and phone and stuff. So, okay. Your what? They're in the car. Well, okay, it's fine. It's not locked or anything, is it? Okay. So, can you tell him what you just told me, or?
Yeah. So we're here. We're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman, and you shouldn't be very long. But there just is a process for paperwork and stuff. But right now, you do have to come with us, and I do have to put you in handcuffs. So turn around for me. I
Requirement for us to come transport somebody in custody.
You know we're going to win this. It's okay.
Yeah.
I'll get you out. For me? All right. Stay silent. Rick knows about this. Candy's on this. Dad's on his way. We're coming to get you, okay? Stay strong, okay? Say your prayers.
Okay, so he's going to go right to the city of Stillwater jail, and if you'll just contact her, then she does this all the time. She knows what to do.
Yeah.
Make sure she knows Stillwater Police Department, not county.
Stillwater Police Department on Lewis. Yeah.
Let her know that we're the ones that picked him up.
And when you say we are
Stillwater PD.
Stillwater PD.
Yeah.
Okay.
That way they don't think he went like straight over and over the county.
Awful experience for a child.
Pat you down. Spread your feet for me. Nothing in your socks.
What about his phone?
So that's going to remain at the police department as evidence. So we'll hang on to it through the duration of whatever happens with the case. Okay.
Generally, once the case is adjudicated, then we'll be able to release it, but we can't until it's over with.
Well,
normally.
his phone cannot be released.
Okay.
Anyways, yeah.
Yeah.
Because of stuff that's on it.
Did he have an ID or anything?
Yeah, and I actually have a copy of the warrant, so I'll give that to you.
I'll just take his ID with me and I'll give it to the detention staff.
Yeah, I can get it out. It's a little shaky.
Here, that's in the ledge. Thanks, man.
24 Central.
24.
10:15.
So my attorney told the police
Oh, my bad.
that we would bring him in. Did you not get that message?
I did, and I called back, and I never got a call back from him.
When did you call him? Because he's called you several times too, he said.
I've only had one voicemail from him, and I called him back after that. Sorry, I'm trying to get you a copy of this warrant. And I haven't received anything from him, so other than that one phone call. And that was several months ago. Probably like
You didn't tell him you were doing this today.
probably the attorney?
Yeah.
No. There would be no reason for me to tell him.
But he left you several messages about Jesse.
He left me one message, and I returned his call, and he didn't call me back. So that I took that generally. I don't want my client to talk to you. So when I return the message and then he doesn't make any effort to call me back, that's kind of what I have to go with.
Okay.
Oh, this is just a copy, but you can have that.
Okay.
So it has the charges listed and the bond and the case on there.
Okay. All right. Thank you.
Okay, you're welcome.
So Butler was charged as an adult with 11 felonies. He faced up to 78 years in prison. But over the summer, after a no contest plea, the court granted him youthful offender status. So just like that, the potential 78 years vanished, and instead he got probation, counseling, community service, no social media, a restitution payment, and if he fails, he could be reclassified as an adult and face a 10-year sentence. If he completes it, his record's sealed. Now, this is what we got to talk about, because we are learning new details about what one of the victims, identified only as LS in court paperwork, what she went through both during her short relationship with Butler and after. The federal lawsuit, okay? This new federal lawsuit was filed in U.S. District Court for the Western District of Oklahoma on behalf of LS and her parents, Amber and Tyler Selvey. And it names quite a few defendants, by the way, not just Jesse Mack Butler. So we have Independent School District number 16 of Payne County, state of Oklahoma, aka Stillwater Public School District, the city of Stillwater, Jesse Butler, his mom Jackie Butler, his dad Mack Butler, School Resource Officer Paul Blankenship, and Principal Walter Howell. So let's remember those names because they come up a lot during the course of this filing. So in this filing, we learn actually a few more details about LS, who's going to turn 18 in January of 2026. It says, quote, LS is a deaf, hard of hearing individual and has an individualized education plan to accommodate her disability. Now, the lawsuit also notes that on top of being Jesse Butler's father, quote, at all relevant times, Mack Butler was employed by defendant school district as the assistant athletic director for Stillwater Public Schools. And by the way, Mack Butler also apparently has strong ties to Oklahoma State University's football program. So he used to apparently be the director of operations for that program. That's according to USA Today. Why does all that matter? Well, first of all, OSU is a huge presence in Stillwater, and there have been accusations that have been made online and in the community that the Butler family's perceived connections could have something to do with Jesse's arguably lenient punishment. Now, there's nothing to say that for sure, but people have been making that connection nonetheless. So, here's how the lawsuit kind of sum things up as we go through it. It says, quote, upon information and belief, Jesse Butler has a demonstrable pattern of disturbing, violent, aggressive behavior. One example of this disturbing behavior is that he would repeatedly slam his head against the wall in the baseball clubhouse when angry or frustrated. Upon information and belief, Mack and Jackie Butler were aware of Butler's disturbing behavior and did not seek help for their son or take any other corrective action. This is how you get to liability, right? They had a duty, and they failed that duty when it came to their son and what he did to others. Now, according to LS, she and Butler were only in a relationship for about 6 weeks, so January 2024 to March 2024. So this would have been when she just turned 16. And according to her, this series of sexual assaults started in February of that year, and it didn't stop there. Quote, on one occasion, in a Walmart parking lot, Jesse Butler forced himself onto LS, put his hands around her throat, and strangled her. A doctor later informed LS that she nearly died when Butler strangled her. LS required surgery to repair the damage that Butler caused to her throat. And the lawsuit also provides us with a better timeline of how and why LS came forward. So, for example, it says, quote, on or about September 11th, 2024, LS became aware that another girl was a victim of Butler. While discussing Butler's abuse at church with the other victim, a youth worker overheard the girls and informed them that unless the girls reported Butler within 24 hours, the youth worker would be forced to report Butler. On September 12th, 2024, LS reported to Assistant Principal Tommy Grant that Butler had sexually assaulted, strangled, harassed, stalked, and abused her. Grant called SRO Blankenship to the office, so again, that's the school resource officer, who, quote, interviewed LS. SRO Blankenship stated LS would have to get her story straight with Butler's other victim and that she would have to go to the Seville Center for Child Advocacy to make sure she was telling the truth. So straight away, there is this allegation that there was some hesitancy to believe what LS was alleging. And the lawsuit claims that it only got worse. Quote, defendant school district did not perform an investigation into Butler's conduct after LS's report. Defendant school district took no action to protect LS from Butler. Defendant school district did not notify staff and employees about LS's report. So if that is true, that is pretty alarming and damning behavior if that can be proved on the part of the district, right? Especially considering that there was ultimately an investigation and later court case involving Butler's actions. Now, according to LS, the day after she made that report, Butler started what the lawsuit calls a, quote, coordinated campaign of harassment. Quote, upon information and belief, Butler called LS and had other students call her on his behalf to pressure LS not to talk to the police about him. The filing also states Mack and Jackie Butler were aware that Jesse was stalking, harassing, and intimidating LS, but they took no action in response. So the Selvey family hoped that filing a protective order would give LS, some kind of peace at school. But their lawsuit claims that the district refused to enforce it. Quote, on September 26, 2024, Amber Selvey filed for an emergency protective order against Butler on behalf of LS. The EPO was served on Butler while he was at school. After Butler was served with the EPO, Walter Howell called Amber and informed her that Mac Butler was crying and taking it really hard when the EPO was served on Jesse at school. During that phone call, Howell requested that Amber report any problems with Jesse directly to him instead of the Stillwater Police Department. Upon information and belief in response to Butler being served with the EPO on campus, defendant school district instituted a new policy that EPOs are not authorized to be served on students while they were on the school campus. Now, according to the suit, it had previously been the district's policy that any EPOs would go into a database, so, teachers and staff at the school would know about it, but the Selveys claim that wasn't done here. From there, the lawsuit states that they started to get reports on how much LS was struggling at school. Quote, on December 9th, 2025, LS's deaf hard of hearing specialist called Amber because LS was uncharacteristically struggling with her school assignments. When Amber informed the specialist about Butler and the EPO, the specialist had no idea what Amber was talking about. Okay, so now you're talking about a potentially important witness at a trial. Amber complained to Assistant Principal Grant about the staff not being informed of LS's situation. Grant responded by emailing LS's teachers to give grace on missing work because LS was having a, quote, rough go of it. On January 14th, 2025, Walter Howell, that's the school principal, called Amber Selvey regarding Amber's complaints with how the school was handling LS's situation. Howell informed Amber that he chose not to enter the EPO into the school's database because he did not want to interfere with Butler's opportunity to receive an education at defendant school district. Wow. Horrifying if true, and also very important for a legal context because, as we'll talk about later with the causes of action, if you can show that two students were treated differently, if you can show preferential treatment, or if you can show disparate treatment, right, of a student, that's key. So the lawsuit claims that the situation just continued to devolve, with the school's resource officer, that SRO, deciding to get personally involved. Quote, on January 22nd, 2025, SRO Blankenship pulled LS out of class for a private meeting, which is against school policy. At the meeting, SRO Blankenship informed LS that he was aware of Butler's habit of stalking LS in the school parking lot. SRO Blankenship informed LS that as long as Butler did not speak to her, SRO Blankenship would not do anything about Butler's conduct. Upon information and belief, SRO Blankenship deliberately pulled LS out of class and then escorted her back to class to embarrass her. According to the court filing, a safety plan meeting was held in January of 2025 regarding LS. Now, the thing about that is, the allegation is, only members of the safety team were supposed to be there, but the lawsuit claims that Principal Howell came in anyway, leaving the door open so that people outside the room could hear what was going on. Meantime, Blankenship, the SRO, the school resource officer, was required to be there as part of his job, but the complaint says he never showed up. So the safety plan that ended up being put together then allegedly wasn't shared with teachers and staff. So the Selveys tried to go over the SRO's head to no effect. They claim, quote, on January 30th, 2025, Tyler and Amber Selvey complained about SRO Blankenship's conduct to his supervisor, Lieutenant Cluck, at the Stillwater Police Department. After listening to the Selveys' complaints, Lieutenant Cluck told the Selveys that SRO Blankenship is friends with the Butlers, so they should not hold SRO Blankenship's conduct against him. Then from there, LS and her family claimed that Butler violated the EPO. How during an alleged incident in February, the complaint states, quote, student athletes were on the basketball court for a school-sponsored event, senior signing day. SRO Blankenship was in attendance, as were multiple members of the administration and staff were present. At senior signing day, in full view of staff and administrators, Butler came within 5 feet of LS to stare at, harass, and intimidate her. Not one school employee intervened on LS's behalf in response to Butler's violation of the EPO. It was only when one of LS's cheer teammates informed a cheer coach about Butler's conduct that anyone intervened. The cheer coach removed LS, not Butler, from the court. So look, Butler was arrested. He was released on bond in March of 2025. We know that. But according to the lawsuit, it wasn't until August 4th, 2025 that, quote, defendant school district finally informed LS that Butler would not be allowed on campus for any reason. But according to this complaint, the alleged harassment campaign reportedly continued. Quote, during this fall semester of 2025, Walter Howell continues to attend football games where LS is cheering and he repeatedly stares at and harasses LS and her family. Now again, as we went all through that, and I'm going to go through the causes of action, these are allegations, right? This is part of a complaint. These are allegations. A lot of this is based upon information and belief. So the idea is, look, this is what we think we know right now based on what we see. It will obviously have to be more fully fleshed out and corroborated through the discovery process, through leading up to trial, to testimony. But now we got to get into the causes of action, okay? As part of the lawsuit, the Selvies have listed 9 claims for relief. I want to go through them. So the first accuses the school district of violating Title IX. Title IX states in part that, quote, no person shall on the basis of sex be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And the lawsuit states the abuse, harassment, and discrimination suffered by LS was so severe, pervasive, and objectively offensive that it deprived her access to the educational benefits and opportunities provided by the school. So you're alleging here a pattern, right? That the school district had knowledge of Butler's harassment and abuse and that she was retaliated against. There was an allegation here that they failed to investigate Butler, that they didn't stop him from harassing and intimidating, that they didn't enforce the EPO, that they banned LS from attending baseball games so Butler could still play, really suggesting disparate treatment, like I mentioned before. The second claim for relief is also against the district, violation of equal protection under 42 U.S.C. Section 1983. Quote, after LS reported Butler's sexual assault and harassment, defendant school district acted with deliberate indifference to her rights. So the idea here, protecting Butler at Ellis's expense. How the school district allegedly allowed a pattern of harassment and intimidation. The third claim is filed on behalf of LS against Jesse Butler, Mac Butler, Walter Howell, and Paul Blankenship, the SRO, for intentional infliction of emotional distress. Quote, defendants' actions in the setting in which they occurred were so extreme and outrageous as to go beyond all possible bounds of decency and would be considered atrocious and utterly intolerable in a civilized society. This is a very broad claim. We're talking about intentionally or recklessly causing severe emotional distress. The fourth claim is what's called respondeat superior, which holds an employer liable for the actions of its employees. Quote, defendants Mac Butler, Walter Howell, and Paul Blankenship were acting within the scope of their employment when they intentionally inflicted emotional distress on LS. Defendants school district and city are directly liable for the actions of their employees while in the scope of their employment. So you really have to show that what the individual players did, what they allegedly did, was while they were working or they were carrying out their official duties and they weren't doing something, independent while off duty. Fifth, so this is against the school district and the city of Stillwater. You have negligent hiring, supervision and retention, and gross negligence. When you talk about negligence, duty, breach of duty, a harm suffered, and that breach caused the harm that was suffered. Now, gross negligence is an extreme deviation from the standard of care that was owed here. You really disregarding the risks, the consequences of a certain course of action. So here it says, quote, defendants negligently breached their duties to LS by hiring, failing to supervise, and or retaining Mac Butler, Walter Howell, and SRO Blankenship by allowing defendants to harass, embarrass, and intimidate LS in the course of performing their work. The sixth claim accuses Mac and Jackie Butler of negligence. Quote, upon information and belief, Mac and Jackie Butler were aware of Butler sexually assaulting LS and could have prevented it. So namely, they knew their son sexually assaulted LS. They didn't intervene. You really have to show that they knew or had reason to know of what was going on. That's how you can potentially hold parents liable for the actions of their child. And the 7th and 8th claims are for battery and assault. They're on behalf of LS against Jesse Butler. So for battery, you have Butler, quote, acted with the intent to make harmful contact when he sexually assaulted LS and strangled her. For assault, quote, plaintiff LS was placed in apprehension of immediate harmful contact as a result of Butler's conduct and suffered fright and terror. So that's about alleged stalking, intimidation, harassment. Now, I believe in Oklahoma, no contest pleas can't be used as admissions of guilt in a civil case. So LS's lawyers can't say, look, Butler admitted to doing all of this. Clearly, he should be found liable for assault and battery. But obviously, that investigation, that evidence, that can overlap and come in a civil case and potentially would be strong in proving claims like this. But the final claim is on behalf of LS's parents against all the defendants for negligence. Quote, as a direct and proximate result of the foregoing, plaintiffs Amber and Tyler Selvey were deprived of the comfort, enjoyment, and society of LS. So in certain cases, a family member can be hurt by the injuries that are suffered by a victim. What did they lose? Now, I should say that the family has not named a dollar amount of what they're seeking in the lawsuit, but the Selveys do claim that they're owed at least $75,000 in damages. That's how you get to the federal case threshold as well. This legal fight, by the way, I should tell you, doesn't end here, because you also have something else going on. You have a victim's rights attorney who has also filed a motion with the state court claiming that her client's rights were violated under Marcy's law. We talked about this in a previous sidebar, because the claim is she wasn't properly consulted or heard before that controversial plea was struck with Jesse Butler. In fact, I spoke with attorney Rachel Bussett on December 15th.
So Marcy's Law is a crime victims' bill of rights, and it was passed into the Oklahoma Constitution in 2018, supplemented by statutory definitions and processes that are supposed to be given to victims. Along the way, if you read through the statement of facts and procedural history in the case, you'll see that there were a number of times where my clients weren't given proper notice. They didn't follow simple procedural aspects of what we're supposed to do as lawyers. There were other times where they were given partial information or no information at all, or the information that they were given was given in such a way that they didn't have a meaningful time to process it, work through it, and understand it. So there are different things that happened at different times.
And is the goal for Jesse Butler to ultimately be resentenced, for the youthful offender status to be stripped away, for him to be sentenced as an adult, for him to get prison time? Is that something, or is it at the very least for your client, her family, to be heard, to just be heard in a courtroom? What is the outcome that you're looking for at this point?
We're looking for an outcome that holds him accountable. And I know there are going to be people that say, well, this does hold him accountable as a youthful offender. But the biggest thing is he hasn't admitted what he's done. For the Youthful Offender Act to work the way that it's supposed to act, there has to be a taking of responsibility. And he hasn't taken any responsibility here. So we need some sort of admission of responsibility at a minimum. Now,
so far, the Butler family, the school district, the city of Stillwater, they have not responded to the federal lawsuit, but we'll definitely keep a careful eye on this and see what happens next. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.